Josh, you good?
Yep.
All right. Good evening, everyone. My name is Aaron Tuckfield. I'm the chairman of the Macomb Township Zoning Board of Appeals. Today is Thursday, November the 7th, 2024. This is our regularly scheduled meeting. The time is 6:31, actually, and I'm calling this meeting to order. Our second item on the agenda today is the Pledge of Allegiance. Please stand with me for the pledge.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Very good. That takes us on to item 3, which is roll call. Mr. DeBruin, please call the roll.
Mr. Tuckfield.
Here.
Mr. DeCoster.
Here.
Mr. DeBruin is here. Mr. Piper.
Here.
And then Mr. Gomicki, I'm assuming Mr. Mazzar is excused absent.
Yes, Mr. Mazzar is of excused absence. We'll actually take a motion to exclude him from roll call votes momentarily. But just so that everyone on the board and the audience and all the petitioners recognizes, Mr. Gomicki is one of our alternates. He'll fill out our board tonight. That is according to our bylaws. And we are at full capacity this evening. Because of that, we do have to have a majority of regular members, which we do have this evening, so we are properly quorumed. All right, with that, I will entertain a motion to exclude Mr. Mazzar from any roll call votes this evening.
So moved, Mr. Chairman.
Support.
Motion by Mr. Piper, supported by Mr. DeBruin. All those in favor, please signify by saying aye.
Aye.
All those opposed by saying nay. That item passes, and Mr. Mazzar is not going to be called in any roll call votes this evening. Josh, I don't remember in our bylaws, do we have to specifically state he's excused?
No.
Okay, because he had let us know with...
He is
a good
excused,
amount of
but you
time.
don't have to state.
Yeah. All right, very good. Next on our agenda is to address any conflicts of interest. This time we're going to call the roll, and if any of the members have any conflicts on any of tonight's items, we have 3 items this evening, please indicate that you have a conflict by saying yes. And if you do, we will go into which item. If you have no conflicts, please indicate by saying no. Mr. DeBruin, please call the roll.
Mr. Gomicki.
No.
Mr. Piper.
No.
Mr. DeBruin does not have any. Mr. DeCoster.
No.
Mr. Tuckfield.
No. All right, so we've all stated no conflict of interest this evening. That moves us on to the approval of this evening's agenda. Is there any motions on tonight's agenda?
I'd move to approve the agenda as submitted, Mr. Chairman.
Motion by Mr. Gomicki.
I will second that.
Support by Mr. Piper. All those in favor, please signify by saying aye.
Aye.
All those opposed by saying nay. That item passes and tonight's agenda is adopted. That moves us on to item 6, which is the approval of the previous meeting minutes. Those would be the minutes for October the 3rd, our last regularly scheduled meeting. Is there any comments, discussion, or motions on the minutes?
Mr. Tuckfield, if I could, I left an updated version. What's highlighted in yellow is what has been updated, so that is the meeting minutes you would be looking at.
Very good, and I appreciate you putting me on there as being excused, and I appreciate Mr. DeCoster for chairing the meeting as well. Any other comments or discussion on the minutes?
I'll make a motion to approve the amended minutes for October 3rd, 2024.
Is there support?
Support.
Supported by Mr. DeBruin. All those in favor, please signify by saying aye.
Aye.
Aye. All those opposed by saying nay. That motion carries, and the minutes are approved as amended on our desk this evening. All right, that moves us on to item 7, which is old business. Item 7A on old business is a variance request for section 10.0311 EF2. This would be with regards to a patio to a side yard setback. And this is for permanent parcel 08072280003. Mr. Box, please bring us up to speed on this.
Thank you, Mr. Chairman and Board. I think you're all familiar with this. It's been in front of you a few times now. It's been tabled a few times. But the applicant is requesting a variance of 1 feet 8 inches. They have a patio that is already existing that they built. It's supposed to be 7.5 feet or 7 feet 6 inches off the property line, and it is 5 feet 10 inches. Again, we've been through this, but some of the pictures here, you see the patio does extend beyond the home. It actually is in line with the bay window, which is a 2-foot projection into the side yard typically. So it was noted by inspectors that they are in fact in violation of the ordinance, so they applied for a variance. What you see here is what was submitted for their permit. It shows that the patio, the blue line would be in line with the house. However, what was constructed has the pink area, which again you see here. That's the 1 foot 8 inch setback into the side yard that they're seeking a variance for. The departments looked at this, assessing had no objection. The building department indicated that it doesn't create any building code issues. Engineering noted that the side yard reduction would provide ample room for proper drainage. Therefore, there's no engineering-related concerns, no comments from fire, no issues from Public Works. Planning did note, it does appear that it does not appear, excuse me, that there are any unique physical characteristics with the property. It does appear that a grant of the variance would provide them with a greater relief than others in the district, and the applicant may provide additional information. So going through the timeline, I know we've been through this before, but just to walk everybody here, it looks like we got some new folks in the crowd. So in May 16th of 2023, they filled out an application and left it with the township for a brick paver patio. You see here ZLM was the applicant, that is the contractor who constructed the patio on their behalf. Between the 16th and the 20th, there were some phone calls with Len, one of the building inspectors. The application was updated based on those conversations. And again, you see here where he updated some of those, where he wrote in the dimensions and put the comment about being distance from the rear property line. There's no comment about being a distance from the side property line because what they have shown would actually meet the ordinance. On May 20th, 2023, it was finalized and approved, and the applicant was notified that they needed to come pick up their permit. It was not picked up until February 8th of 2024, so sometime later. And at that point, that's when typically the work would begin, but at that point, work was already constructed, the patio was already completed, so an inspection was scheduled for the very next day. Inspectors went out the very next day and rejected their patio based on the fact that they are projecting into the side yard farther than what the ordinance would allow. Again, we went through this last time, their plot plan, looking at their neighbor's plot plan. These are two different independent surveys that were done indicating that their home is the required distance off the property line. And staff cannot support this request until practical difficulty has been identified.
All right. Thank you, Mr. Box. Is there anyone from the petitioner in the audience? Yes. If you could come forward, go ahead and sit down at the center table here, state your name and address for the record, and give any comments you might have.
Good evening, Gary Gunnernock, attorney on behalf of Todd and Diane Pack with reference to this variance request. I delivered to the township on November 4th updated position letter and an updated survey. Did you receive it?
I believe we have received it.
I outlined in that document the nature of this particular request and what I believe is the appropriate case law that a ZBA has an affirmative obligation to grant variances. One thing in that application document, when you look through it as to a patio, I would think from an outsider's perspective that the building department or the planning department would say on there that you have to be 20 feet from the rear and 7.5 from the side yard so that people know it without having to study the ordinance. And I don't think that's on there. In conjunction with this, as some supplemental information, I'd like to provide some additional pictures of my client's property. Can I approach?
Sure. Just be cautious with the step. We've had people trip on it before.
Oh, yeah.
Hate to have that happen.
I was at it years ago at a city of New Baltimore meeting, and the council person, he fell up.
Oof, that's no fun.
Unfortunately, he wasn't hurt,
Thank you, sir.
other than embarrassed.
Thank you.
Thank you. Thank you.
So in this additional packet, we point out some additional pictures that shows the layout of my client's property and the measurements. And the uniqueness of his property is in particular his home. It has the bay window on the first page that juts out, and then there's a bay window to the side. And so when they built it in conjunction with how the bay window projects to the back and to the side. And I've been there on a couple of occasions, and the layout makes it safer when you come out the back door, that step, and then when you go to the left side as you're facing the rear of the house, down that step and out, and there's no encumbrance to the fire department or anyone else, because the other departments, they all indicated that they had no issue with how this was. And from a safety perspective, this layout is probably better than if it had to be in line with the side of the house, because you have less room to step off the patio. And in this, on the second and third page, it shows the bay window on the side of the house, and then the measurements to the step. And then we also gave to you some additional photographs of a property on Berry Field, 54268 in Macomb Township, illustrating how that particular house has a similar setup and was allowed. And there's various pictures of that showing how that extends beyond that property owner's house. The supplement 3 is some additional information similar to that, with an aerial on the next page as to a layout on another home on Lamont Street, then another house on Howard Street in Macomb Township. And the Howard Street one at 15736 is quite similar to my client's property here, where there's a bay on the corner of the rear portion of the house that extends off the rear of the building and off the side, and how they configured their patio to facilitate a safe and easy ingress and egress out of that home. And that's what the similar pictures say or show, demonstrate that it's not unusual in Macomb Township to have houses with a bay window that is to the back and to the side. And when that occurs, you have a safety configuration that needs to be addressed. And like I said earlier, if Macomb Township wants to bring out this particular information as to setbacks, then why not put it in the application so that people can see, whether a homeowner does it himself or through a builder, a landscape person, that these requirements are 20 feet to the rear and 7.5 to the side. And then in this most recent supplement to you, after my involvement in this, I suggested to my client that they have an updated survey done, which they did by Polaris, and that survey shows that when this particular subdivision was platted, the plat for those certain areas was supposed to be 350 feet from the survey monument, but in fact, they're 349.61. So obviously, at some point, the township allowed this particular subdivision to be platted. It was platted, but the monuments are in the wrong space, wrong place. So that adds to items not being consistent. And obviously, when the plat was done, presumably the township engineer would have, or surveyor would have certified that the monuments were in the right place. This 2-foot variance in essence request, that's in round numbers, isn't detrimental to Macomb Township. And at the previous meetings, the neighbors came and they indicated that they do not have a problem with it. And it's not an obstruction to the neighbor to the right. Their property is fenced in because they have a swimming pool. And at one point when we were first involved, it was an impression that maybe that fence was 6 inches onto my guy's property, but it's actually in the right place. So we would ask you to grant the variance as submitted, and in essence, a 2-foot variance for the 7.5 feet versus 5.5. And I think it's an equitable resolution, and when zoning ordinances were first adopted in the United States, there was litigation as to whether or not municipalities could regulate land use. Eventually, the Supreme Court said, yes, they could, but in the process, they had to create the ability of the property owners to appeal those zoning requirements, and that's why you have a ZBA. And that's why, through the administrative process, this is what we're asking for. Because if in the application it said 7.5 feet and 20 feet, they would have known, excuse me, what the dimensions were, and prior to building it, they could have come to the ZBA and asked for a variance, and then if the variance was granted, build it pursuant to that. This is kind of an unusual situation, but it's not the first time where somebody built something and then came to the ZBA, whether it's in Macomb Township or some other municipality, to ask for the variance request. And it's just like on occasions, people build something, but they don't get the appropriate permit for a shed or accessory building, and then there's a permit application after the fact application, which does occur, that allows the person to have their building stay after the appropriate inspections are done. So we would ask that you grant the 2-foot variance request, and Todd, do you want to say anything?
Yeah,
What's that?
yeah, I'll accept.
Okay.
Yeah, go ahead and you can pull another chair up there, that should be fine. And if you could, sir, I know we've talked before, but if you could put your name on the record, I'd appreciate it.
Hey, good evening. Todd Pack, homeowner for 548 Carnation Drive. So just a couple of items. I think one, you had asked when we were here last time about photos of an existing structure, because as we mentioned, we had a wood deck that was there prior that was pulled out that was in alignment with the bay window. So included in the packet that was submitted to you is actually an aerial view of that, so you can see that. So again, I don't necessarily know that that changes a whole lot, but just so you know, it was a replacement of that existing structure that was in fact aligned with the bay window. And again, there's an aerial view of that within the package.
Could you note where that was? It's a
Yeah.
somewhat substantial package, and I'm not sure if I caught that.
Yeah, I'm sorry. Give me a second, I can tell you. You mind if I walk up to you? It might be easier to show you.
No, I do not mind. Just again, mind the step there.
Yeah, yeah. No.
Is that 2B, Aaron?
Where is it?
2B, is it 2?
Yeah, it's section 2B, it's just that there's not an identifier on this for 2B.
About 7 or 8 pages in.
No.
Oh.
Sorry.
I do see it. I see it.
Sorry.
Yeah.
Yeah, thanks.
That would be, you're referring to this,
Yeah, yep.
okay?
Correct, yeah. Sorry about that. So I mean, just, again, it was just a refresher from when we were here last time in terms of one aspect of it. The other piece of it that, when we were here last, that we had talked about was projections. And so one of our rationale was the idea of the projections and such, and as you may recall, it's not actually clearly defined. It's not actually in the definitions anywhere within the township. The township stated that a projection was anything that wouldn't normally touch the ground or that would not impact drainage. But within some of the own ordinances of the township, specifically, which is in there, 10.2506 includes, under their projections, things like ramps. Go ahead.
The ordinance number is not familiar to me. Josh, is that within our standard ordinance? Is that maybe in?
That's in the town center ordinance, which is not where they reside.
Okay, I just want to verify. Oh,
No, you're
go
good.
ahead.
So my point is that there's inconsistency, there's really a lack of definition that exists, but within the township's own information, within that section 10.2506, it includes front porches and other things. Because when we were here last time, we mentioned that other municipalities that have more clear definitions, in some cases, in fact, include things like porches and stuff that touch the ground. So again, it's just for a point of clarification. Because last time the township's position was that a patio or anything that touched the ground is not considered a projection. We did mention when we were here last, we didn't touch on it this time, but just the issue of the steps based on the height which you got in that secondary package with some of the measurements. There's only 7 inches or 7.5 inches from the side of the door to the edge of the bay window when it starts projecting back. And then from there, there's only 2 feet to the side of the house, right? And so in order to build out steps that weren't going to be a hazard, it's almost impossible. And so the steps as they are today, if we actually cut based on what the township has suggested, it will violate the IRC as it relates to the width of the steps and the difference between the first, second, and down to the 3rd step. So again, just, it's more of a refresher because it was August when we were here, so I don't remember what everybody recalls. I think for the most part, that's it. I mean, I just, you know, from our side of it, and I know that, you know, you have to evaluate these things independently, but we hired a contractor who pulled the permit. And in the end, I think unfortunately, there was communication issues between how are they processing the permit process when the township obviously picking up in February. Those aren't things that we could possibly have known. In addition, and it's probably a question for Josh, he showed you the plot plan for what was submitted to the township for approval. What he didn't mention was that with the documents we were provided, included a schematic of the actual patio, which in fact shows the side of the bay and it extending to the bay. And so I don't know if the information I have is incorrect or if the township chose not to include that, but I can tell you the schematics that are included in that show that clearly.
If I could request, is that something that is in your packet anywhere?
It is.
Could you indicate the page on that?
Yeah, so there's 2A.
2A.
2A has part of it, and then more specifically, I had the page on here.
This page here.
Yeah, so it's gonna, the other one that's gonna look similar, that's not a, I guess a digital graph. It actually has a schematic, looks like this.
It's
Yeah.
a ZLM.
And so
See it?
if you look to the right-hand side, you'll see the bay pop out. And this piece specifically, we were told was submitted to the township during the approval process. And you can see the alignment where the steps would be in the bay window and the doors and such.
All right. Did you have any other comments?
No.
Any comments for the petitioner from the board?
I do have a quick question.
Go ahead, Mr.
I'm curious why the original plan then showed it flush with the house if they plan on doing that. And then as a secondary question, why it took so long to pick up the permit, because if it was picked up right away, this whole issue might have been avoided.
I completely agree with you. Fair question. I mean, so my understanding as relates to the timing is that they had gotten the approval verbally to move forward. And why they waited so long to pick up the actual physical permit, I don't know. I can say when we were here in October, a comment was made that it's unusual for someone to begin work prior to having picked up the permit. At least from ZLM's communication, that's not necessarily all that uncommon. And again, I have no idea, right? It's not the thing I specialize in, but according to them, it's not that uncommon. And then your first question, at the end of the day, somebody, when they submitted it, drew the line in the wrong spot. And again, there's not any way for us to have known that, right, when they submitted everything, but that's the feedback we've gotten was just simply that they drew the line in the wrong spot.
I look at it, that goes both ways. There's no way the township would know that you're gonna do something different either when you're submitting a plan, lining it up with the edge of the house.
Agreed with you, but that's my only argument regarding the schematic, which they didn't include in their information, but again, as far as we know, was included, and that does show the bay window.
Yeah, and the schematic showed it extending to the basement.
Yeah.
Yeah, so that 2A showed it as a schematic extending to the bay window on the side of the house.
Yeah. I guess in the end, I mean, it's unfortunate that we're here, you know? I mean, because as a resident, you look for there to be protections to the resident who actually did everything possible to make sure things were done correctly. by engaging somebody, paying for the permits, things of that sort. So we did everything right, but then we're at risk to basically be 100% responsible. So, I mean, it's not within your purview, I understand, but in the end, if the township has an issue, it should be a discussion between them and the contractors who didn't do things as understood or doing it correctly, right? It's not the resident. There should be some safeguards for the resident who's not a cause, I guess, maybe to phrase it, you know, within the issue.
Any other questions for petitioner?
I got some comments.
Go ahead, Mr. DeBruin.
So, obviously, this is a difficult situation because just to how it played out. But what I'm looking at after 2A is what was stamped received by the township and what's represented stamped received from the township. I understand your discussion about how would you supposed to know, but I'm having a brain ellipse here. Hold on. You understand our obligation is to find a practical difficulty on why, because this could apply to other things in the future. So I guess I'm asking, is your contention of the survey what you're saying is your practical difficulty?
Well, there's two parts to that. So when you look to my letter of November 4th, that 2A, that schematic with the aerial, shows the patio going to the front edge of that side bay window. So when you look at that, it's consistent with what was built.
I'm not
Then
seeing
when-
that stamped as received, though, so I don't.
What's that?
I'm not seeing, I see what's stamped as received by the township. I'm not seeing that. That's, it's hard for me to take that in. I realize it exists, but I see what's officially
Oh,
stamped by
yeah,
the township
so
as
there you're looking
received.
at the mortgage survey
Correct.
document. In that line, someone wrote in a line, and it shows the dimension at the back, 20 feet from the rear lot line, but there's no indication as to the dimension set off on the side yard setback between the property line and where the patio was gonna be built. There's no dimension there at all.
Well, there's nothing noted anywhere else where the drawing is correct as well. I mean, they didn't note things that were correct. They only noted things that were incorrect. That's my understanding of what's going on.
No, the 20 foot's correct.
It says minimum of 20 from rear lot line, and that was correct in the drawing? That was correct in the drawing?
Right.
Yeah,
If
so
I-
here, let me go
Josh,
back here.
Josh, if we could, I think one of our building department individuals are, if you want to, Mike, if you could just roll over to the table. And also, if you could just put your name on the record.
Sure. Mike Badamo, Assistant Building Official. So I was not the individual that reviewed this. I got involved much later. But the initial application showed a dimension that showed the patio closer than 20 feet to the rear property line, and the reviewer contacted ZLM, and that was noted, that distance was changed. And if you look at that plot plan, the way that's drawn, it's in line with the house. The house is more than 7.5 feet off the property line. There's no need to make a comment. The way it's shown, there's no need to emphasize anything. It's shown as if it's 7.75 feet off the property line. So that's how we got to this point.
Thank you.
So again, I'm back to my question of, is the practical difficulty you're looking to present the results of the survey and how things are off?
Yeah, that and part of it, and the safety concern of coming in and out, and on the practical difficulty side, that's what people apply like before they build to show why they should have a variance from the normal requirement. And if they had known that built the way it was, that they were off by 2 feet, they would have come and asked for the variance beforehand. And that's why ZBAs are in existence, to allow people a variance based on the nature of their particular property and setup, and how the bay window on the backside and the side yard affect normal ingress and egress. And we've shown to you that other facilities in the township are similar encroachments. It's just like when a person wants to build a pool in the backyard, but there's a backyard drainage easement or utility easement. Different municipalities grant the easement subject to, if there's ever a problem, that they have to take, especially if it's an above-ground pool, to remove it so that utilities can get in to do what they're gonna do. And that's what's transpired in this situation. And as I said in my letter, case law basically says that property owners have certain rights in their property, and that ZBAs are set up to grant variances, and that they have an affirmative duty when the property owner requests it to grant it.
If I could, Mr. Bruin, I don't know if you're done. And I apologize, I know you've been here before, but I have not pronounced your name right. Is it?
You're not the first, me.
is it-
You're not the first guy not being able to.
I know, but I know you've been here
Gendernellik.
before. Gendernellik? Okay. To our legal counsel, Mr. Gendernellik has mentioned, I believe that's the second time, and I wrote it down here, an affirmative obligation to approve variances. Can you speak to that for a moment?
I mean, I can speak to it generally, that there is case law that talks about where a property is unusable, where it can't be developed or used in any purpose, that there might be some affirmative obligation to grant some variance if that would in fact then make that property usable and to bring that property back into, to use for the private ownership. I don't think that applies to the case here. I think the standard simply here before you guys tonight is there or is there not a practical difficulty in complying with the ordinance, the side yard setback ordinance, and you have no obligation to find that practical difficulty. That's your subjective job here tonight.
So to clarify, when a request is made, we are not obligated to approve it.
No.
Otherwise, I'm not sure what our point here would be. We would just auto-approve. And I just want to make sure I'm understanding that correctly and I'm not mistaking our responsibility here.
To be very clear, the standard is practical difficulty, and that's the job here tonight, is for you to find if there is or is not a practical difficulty.
Okay. As the attorney had mentioned, there was a number of references to case law. Do you have any comments on the case law as given and anything that we should be paying attention to with it this evening?
I do not. The standard that you always apply in the ordinance and in the Zoning Enabling Act for the definition of what is or is not a practical difficulty is the legal authority that should control your decision here tonight.
Okay, all right, thank you, sir. Any other comments for the petitioner or for the planning department? Just one second, yeah. No? Go ahead, sir.
I just want to reiterate, and again, I understand there's not consistency in it, but again, what is stamped by the township on that schematic does show it going to the bay window. So again, they keep focusing on one piece, but they're ignoring the second piece of this. So I just want to make sure that's perfectly clear.
I do want to ask the question, last time, and I should remember this more than I do, there was some contention as to the dates and when the permit was filed. I just want to be clear, is there anything that we should be specifically considering from your perspective with regards to the dates, or has that been resolved?
I think the only aspect of the dates to me that matter is that a verbal approval is apparently provided. I will say, and I have a copy of the contractor guide to supplying or applying for permits, and nowhere in there does it say that a verbal authorization is sufficient. And so I feel like the only reason the dates are relevant is that this thing went on 9 months before anything actually occurred. And again, it's not my fault, not your fault, but I think it's a communication issue between the township and maybe how they process things, and also the contractor and their follow-through.
Okay, any other questions?
Good.
With that, and without objection, I'm going to open up to the public. Is there any members of the public who would like to speak on this item? If you would, please come forward to the microphone, state your name and address for the record. Seeing no one and without objection, I'm going to close public comment and bring it back to the board. I did have a couple of other things. Josh, and perhaps Mike, flat work. As opposed, this is raised, the patio is raised. I believe flat work going along the side operates with a different side setback. Is that the case even when it goes past the back plane of the house? What is the standard for flat work?
I guess I'm not understanding.
So you can have a sidewalk down the side of the house, and
Correct.
it's closer
A
than
service
7.5.
walk, yes.
Correct. And I'm assuming that it is allowed to go past the back face of the house so that it could make some sort of rotation, and it would maintain. Is there a limit to that, or is it
A
just?
service walk needs to maintain 3.5 feet off the property boundary.
Sorry, go ahead, Mike. Yeah, I think Mike knows what I'm
I
asking.
understand your question. You're asking how far can the service walk past the back corner and then marry
Yes.
into the patio itself? So That was offered as a solution because of the series of steps coming out of that house.
Yep.
It made sense to at least give him, I'd say 8, maybe, 8 feet past the house, at least giving him another 3 feet past that final step, and then, pull the patio into the appropriate setback from that side property line. So,
And if I could, and I believe you're, if not the main plan reviewer, I know you're one of the main plan reviewers for the building department, if it was only 8 feet there, would you have considered that requiring a variance, or would you have accepted
no,
that? Or
that could have been handled without going through this process. I could defend that as being a service walk, which has a separate setback than the patio proper, which has a greater setback from the side property line.
Right, okay.
So this could have been, resolved in that manner, so.
Understood, understood. I appreciate it. Thank you.
Can I address that question?
Yes.
And Mike can stay there. I think under your ordinance, Macomb Township, your sidewalk to the back only has to be 4 feet off the property line.
Yes,
So
something of that
if you
nature.
had a 10-foot side yard setback from where you built your house, your sidewalk could be 6 feet wide, and you'd add 4 feet off the property line. So this, in essence, the side is in essence a continuation of a sidewalk, or it's similar to a sidewalk. And it's my understanding in some municipalities, for flat work, you don't even need a permit. So I think that interplays with this particular project.
Well, if I could, I would just say that from my perspective that the difference between flat work and a raised patio is significantly different. And as a builder, I've pulled a number of permits. And typically, you do need some type of zoning permit for exactly this reason, to put placement on a property and to confirm that it's abiding with setbacks and of that nature. I guess I would ask to the petitioner, and I want to back up and clarify one thing. We've talked about the permit quite a bit, because obviously there's been timing there, and I normally mention this. I think I mentioned it last time, but I'm going to mention it again. We typically, either to the positive or the negative, we do not consider whether there was a permit applied for late or early. So we don't give, I'll say, negative points because the permit was applied for late, or positive points because it was applied early. We are supposed to look at it as if nothing was built and no permit was pulled. We are looking to see whether it fits the property. So to a certain extent, that's not even to a certain extent, that's what we're looking at. So I guess my question for you would be, why would you not want to construct, or what would keep you from constructing this patio in such a way where you could allow 8 foot off from the house, abide, as Mr. Badamo has mentioned with the ordinance, maintain the safety to the door wall? What would keep you, what would be the practical difficulty that would keep you guys from abiding by the ordinance in that regard?
I mean, from my side of it, I mean, it's a solution, right, that resolves the safety aspect of it. It's not ideal, right, in the sense that we prefer it to be as it is. But I mean, to your point, that's our primary concern, is gonna be the safety aspect of it. And as you may recall, when we were here last time, like for us to do a service walk, a traditional one, even Josh made the comment that it would be difficult, if not impossible, because how narrow the yard is right on that side and such. So, in fairness to you, it would be difficult to argue a practical difficulty beyond about that 8 foot marker.
To our
Can I approach you on that question?
yes.
Because I want to show you this picture.
Again, careful of the step.
Yes, I appreciate the word. So I take it what you were saying is this residence as it exists, this is the existing patio that put a sidewalk from, let's say, up by the garage back along here, as long as you're 4 feet off the side yard property
For
line.
clarification, I'm just going to look at Mr. Badamo. It's 3.5 feet, correct? Just so I just want to make sure we're.
Property line?
I just want to make sure we're speaking about the correct distance. What I'm stating or asking is what it sounds like the building department had offered, or not offered, but had mentioned so that it could be in compliance, would be that the sidewalk would go around the projecting bay and meet up with the patio nearby the door wall, and that this portion to the back would not be here, but this area would maintain to the edge of the bay to maintain the safety of the house, but also to maintain some semblance of agreement with the ordinance as it's written.
Yeah, so like on, off the rear property line, like where this bay window is, or rear of the building, would it extend 8 feet towards the back?
I think we could discuss it more. I'd be hesitant to point too much more of the picture because I think we could speak at cross purposes, and I don't want to have confusion pointing at a picture with angled lines on it. My thought is that the sidewalk could go past the bay projection and turn left, essentially immediately into the patio, not going further rearward from the house than 8 feet. I think would be the clearest way I think I could describe that.
Not
Which
further than 8 feet, right?
I believe that was what Mr. Badamo indicated, that they would feel comfortable, would abide by the ordinance as a portion of the step.
Just to clarify that, and I apologize, it's not about putting in an actual service walk necessarily, but it's allowing the existing patio as it is on that side to be maintained and to go out 8 feet, right, towards the back is what we're saying, right? Because I don't believe, based on those measurements, that we can actually technically put in a true service walk.
I suppose that it is theoretical, only that portion of the patio I could see combining with a service walk to that distance and still applying or abiding by the ordinance.
Understood, okay.
They did show us a drawing of a deck that was there previously. It is a different type of structure. It does seem to show the same outline. Can you speak to what may have been, I'll say may because we don't know those permitted, a legal non-conforming use that was replaced by a patio? How does that work if they're replacing a deck that was in the side setback with a patio using the same footprint?
If there was a pre-existing legal non-conforming use in the deck and its location in relation to the side yard setback, once that was removed, that previous legal non-conformity no longer provides any protection, and then anything that would be replaced even to the same specification
Would have to-
would
So if they were
not be
modifying the existing deck or working on it or altering it or repairing it, that would be able to maintain, they wouldn't have to tear it down, assuming it was a legal nonconformity.
So
But
the
as soon as
question-
they remove it, it becomes, sorry, go ahead.
No. Once it's removed, then that protection is gone. If there's modifications to a legal non-conforming use, then the question then becomes, are you increasing the non-conformity when you apply that? And by removing the deck and replacing it, those protections are gone, and you look solely at the patio today and its compliance with the ordinance.
Okay. I did want to touch briefly on one of the definitions that you gave, just to make sure we're clarifying that. I believe you referenced a portion, and Josh can correct me if I'm wrong, from our town center code. The town center code is highly specific, form-based code that only applies essentially to the square mile around us. It is very specific to homes, and it does not apply anywhere else in the township. There's actually far more restrictions in there. If we were to apply that code to your house, I'm not sure that the patio would apply in the first place. So I just want to mention that. And the other thing that I wanted to mention, just for the record, is that I would hope that we do not have to put every applicable code and ordinance on our permit applications, because if we do, the builders will be bringing out an encyclopedia every time they have to go put it on. I believe as a builder, there is a obligation to know the code, to know what you're building to, and I find it, I think there's an obligation for them to know it. So I would just speak to that briefly. All right, is there any other questions, comments, or motions on this item?
I have one more question.
Go ahead.
So this drawing that was also stamped received by the township, that I think this question more for legal. This doesn't have an exhibit on it, but it's right after that mortgage statement. It's right after the application for building permit, and it's right before the mortgage certificate that has the other drawing on it. If this is, I'm assuming this was received at the same time as, they're both stamped with the same date by the township. If in fact the township received this, and it can be established that there was some oversight in some way, does that in any way affect our decision? We're just deciding on whether there would be some other recourse for that, correct?
Potentially, but yes, your job tonight is to apply the practical difficulty standard.
Despite whether there was an oversight at the time of permitting.
That's correct.
Thank you.
Any other comments?
I'll just make a quick comment. I personally don't see I do not see the practical difficulty here. I'm gonna hold my, motion to see if anybody else has one, because mine would be to deny the variance, so I'm gonna hold mine.
Any other comments? Mr. Box, I should go back to you. Had raised your hand earlier, and I think you were good, but did you have any other comments you wanted to add?
No, I think Mr. Badamo answered those.
Okay, and thank you for Mr. Badamo for being here, I appreciate it. Well, hearing no other comments, Mr. Coster, if you had a motion, feel free to make it.
Yes, my motion will be to deny variance section 10.0311EF2 with regards to allowing the patio with a side setback of 5 foot 10 feet when a 7 foot 6 inch side setback is required.
Before I ask for, actually, I should ask for support first. Is
Can
there
I-
support?
Can I
We can have discussion on the motion, but we should get support first.
clarify the motion before I second it?
If you'd like to, why don't you second it, then we can have discussion. I'm sure
Second.
we'd be able to clarify. Go ahead with discussion, Mr. Mikia.
Thank you, Mr. Chairman. I would just reiterate that it is no practical difficulty unique to the property has been identified, that it's not harmonious with the spirit of the ordinance, and that the ordinance does not deprive the applicant of rights commonly enjoyed by the general public in the district. If the motion maker is amenable to that.
Sure.
All right, the motion has been amended and seconded, and I would just add for the record before we go to the vote as well, discussion on it, that I believe that the difficulty of health and safety has been addressed by the potential that Mr. Badamo has referenced, which I appreciate the petitioner bringing up. All right, with that said, Mr. DeBruin, would you please call the roll? There's a motion with a second on the floor.
Mr. Tuckfield.
Yes.
Mr. Gamikia.
Yes.
Mr. DeBruin is a yes. Mr. DeCoster.
Yes.
And Mr. Piper.
Yes.
That motion passes.
All right, thank you, Mr. DeBruin. Thank you, gentlemen. Appreciate you coming in. All right, that takes us on to new business, item 8A. This is a request for a variance from section 10.0311EF3, permanent parcel 0822426-037. Mr. Box, could you please take us through this?
Thank you, Mr. Chairman and Board. This property is located west of Card Road, just north of 22 Mile, as you see on the screen behind you. So the existing conditions here, there is a 60-foot wide private easement for the Miller Drain along the rear property line. And in addition to that, there's a 12-foot wide storm sewer easement immediately east of the Miller Drain easement. The property is rectangular in shape, but a typical lot in the township would be 70 by 120. This lot is approximately 78 by 180. I guess it varies a little bit because it's not completely rectangular, but it's roughly 78 by 180. So you see it's much deeper than a normal lot, and a lot of that has to do with the fact that there is those easements on the rear of the property. So the ordinance would require a minimum separation distance of 10 feet between an in-ground pool and the principal structure. And as you see here, what they're proposing is an 8-foot separation distance rather than a 10-foot separation distance. The departments within the township took a look at this. Assessing had no objection. The building department noted that it does not create any building code issues, no issues from fire. Public Works indicated no issues as long as the pool and any concrete surrounding the pool do not encroach into the easement. Engineering had a number of comments. While the presence of the Miller Drain and storm sewer easement does limit the amount of usable rear yard, the applicant is asked to confirm that the pool's design cannot be reduced or adjusted to conform with the 10-foot separation. This information may provide a better understanding as to whether a variance requested would provide them with greater relief, and the applicant may clarify whether the spirit of the ordinance will be observed and public safety and welfare secured. In the planning department, Melissa noted that there is, again, a 60-foot wide private easement for the Miller Drain, a 12-foot wide storm sewer easement. In the presence of these easements does limit the amount of usable rear yard. But again, asking the applicant to confirm that the pool couldn't be reduced or reconfigured to meet the ordinance, and they can clarify again whether the safety would be secured. So our recommendation would be that although and easements do exist, it does appear that it's possible to reconfigure or resize the pool to meet the ordinance. So staff would defer to the applicant to identify a practical difficulty. I did mention how deep this lot is, so when you look at the depth of a normal 120-foot lot, the vast majority in the township have a 6-foot shared easement, which they have the full 12 feet here, but that leaves you with roughly 114 feet of usable space. When you take a look at this, if it's roughly 180 feet in depth, and you take off the roughly 72 feet of easement area, it would provide a similar shape as a standard 70 by 120. However, it does appear that maybe the house is set back a little bit further because the rear yard itself would be slightly smaller than a standard 70 by 120.
All right, is there any questions for Mr. Box?
I have a question.
Go ahead, Mr.
So you're
Green.
saying that normally there's a 12-foot easement that's shared by the two neighbors, and in this scenario, that they're,
That's typically how it would work, yes. It runs along the property line, and you've got 6 feet on one backyard and 6 feet on the other backyard. In this case, all 12 feet are in their rear yard.
Mr. Box, I did have one question. I know that this particular portion of the ordinance has been mentioned at Planning Commission for potential adjustment. Where is that in the process right now?
We have been looking at that. We've tossed some numbers around. At this point, we don't have an exact answer for what the updated ordinance might look like. One of the concerns that has arisen most recently is that, especially with multi-story homes, the fire department may need that space to get a ladder up to a second floor without the angle of the ladder being in the pool.
Okay. Do you know when, obviously ordinance writing is a tedious business, but do you have an understanding of roughly when that might be brought forward if it's something that's going to be changed?
We are hoping to get that in front of the Planning Commission as soon as possible. We're hoping by the end of this calendar year or very early in the next calendar year, and that would be a part of that. We are finalizing some of the definitions right now, so we're making good progress in the past few months. So it's coming.
Okay. All right. Very good. Is the applicant in the audience this evening? Thank you. Go ahead and come forward. State your name and address for the record and give any comments you might have.
Matthew Nooner, Anna Nooner.
If you could, if you can pull the microphone just a little bit closer. And make sure Ed can catch you back there. Go ahead and say it into the microphone.
Matthew and Anna Nooner.
Good there, Ed? You can hear him?
Yeah, he
Okay,
found it.
very good. Sorry. Just want to make sure you have it on the record.
49489 Golden Gate Drive. You're looking to get an in-ground pool. As you can see, there are a few hardships here. We've lost quite a few feet, and the 8-foot setback that we're at, well, the 2-foot variance that we're asking for to make it 8 feet. We've gone a few different ways with this pool, trying to redesign it, different shapes, kidney shapes, squares. The ideal that we wanted to have a decent-sized pool obviously has been cut down tremendously from what we originally sat down with the pool designer. As you can see, we tapered both sides of what would be the south side of the pool to try to get it as best as possible to fit the ordinance. Short of actually shortening the pool, I think it was 3.5 feet. That would be the only way to get around the large 10-foot variance that this township has compared to the surrounding townships, as you just stated. So we're asking for this variance to be able to have the pool that we're looking for, that we would like to have.
All right, very good. Any questions? And I should ask you, was that all? Okay, very good. Sorry, I didn't mean to
You're good.
jump the end of your comments there. Any questions for the applicant? Hearing none, I will open it up to the public. If there's no objection, is there anyone from the public who wishes to speak on this request? Seeing none and without any objection, I will close public comment, bring it back to the board. To the applicant, obviously, we're going into the winter season. I would assume that this is not going to be constructed, best case scenario, until next spring.
Correct.
One question I would have for you, in the process of updating our ordinances, we consider various areas, and this specific dimension has been considered whether it should be changed or not. I don't know, as you heard from Mr. Box this evening, whether it would or not. It's possible it would stay the same. It's possible it would decrease, possible it would increase. I don't know the result of it. But it sounds like it's something that we would be considering sometime in the next few months. I can't speak to what the board would say tonight, but I would check to see your thought process on if you would consider waiting for that, because if it's possible that process may result in no need for a variance. It's possible that it may need a larger variance. I don't know what the result is, but I wanted to put that out there, mention it to you, so that you were aware of that in the process and see if you had any comments on that.
As you said, it could go either way, right? So unfortunately, I would love to come back here and do this again in February if it, well, I guess I wouldn't have to, right?
Right.
If it got reduced to 8 foot, then I would be fine. I wouldn't be here.
I guess we've been at this for like over a year and a half. I've been playing Tetris, as you can see how the art is. We always
Ma'am,
knew we
if you
had-
could, I think we know who you are, but if you could just put your name in the record.
Anna Nooner,
All right.
4949 Golden Gate Drive.
Thank you.
So we always knew we had the big variance easement in the back. So when we started playing with this, what we were gonna do, it was a huge surprise that we had this whole sewer easement. So I went back and forth with the water department that I can't even put concrete in there. So where we got the 14-foot pool was, and bring it into the houses, because we just need so much concrete, you know, just on the back side, just to be able not even to get into their easement. So really, it's been playing Tetris and trying to, I've been at this for a year and a half.
Understood.
So trying to wait, you know, a whole nother year, 2 years. With that western exposure, that backyard is like an additional 10 degrees hotter. We have a beautiful patio, as you could see, 2-tier stone, everything, that we put in 2010 that we really rarely use, sadly, because it's so hot back there. So
And just so I can make sure you're understanding me, I am not pushing you to go in a different
Oh, for
specific
sure.
direction. I just
For
want to make
sure.
sure you understand where we are in the process.
And
as a
last
whole.
time when I had talked to, I think in the summer, to the building department, it was mentioned that it was in the works, but it's been mentioned for a while, and there was no time frame on it. So, and our plan is, as soon as the spring comes, we wanna start digging.
Okay, very good, thank you. Any questions for the applicant from the board? Go ahead, Mr. DeBruin.
So if I heard you correctly, you are basically, I don't want to put words in your mouth, but you're saying that your practical difficulty is that increased easement space that's greater than what it would normally be.
Correct.
Thank you.
Any other questions from the board? Is there any motions?
Mr. Chairman, I would like to make a motion to approve the variance to section 10.0311 EF3, based on the fact that normally that 12-foot easement would only be 6 for the drain and sewer. It would be shared by another property owner. I think that creates the practical difficulty that, for the pool to fit in their space.
All right, very good. Thank you, Mr. Piper. Is there support?
Support.
Support by Mr. DeCoster. Mr. DeBruin, please call the roll.
Mr. Tuckfield,
No.
Mr. DeCoster,
Yes.
Mr. DeBruin is a yes. Mr. Piper,
Yes.
and Mr. Gomikia.
Yes.
Motion passes.
Very good. That motion passes.
Thank you.
Appreciate it. Hope you have a good spring.
Thank you.
All right, that moves us on to item 8B, which is a variance to the zoning ordinance, section 10.1603B33A, and section 10.1603, also 33A, two from the same, should have known that before I read it out. This is for permit parcel 08364522022. Mr. Box, please take us through this.
Thank you, Mr. Chairman and Board. Most of you are probably familiar with this. You were here a few years ago on the same site where they were seeking a very similar variance. So what they're seeking, as you noted, Mr. Tuckfield, is a variance to allow a reduction in the call box location, which is standard requirement is 300 feet from any residential property. They would like to narrow that down to 82 feet on the west side and 99.1 feet from the north, as you see in the drawing here. So again, I mentioned you've seen this before. Back in November of 2021, a variance was approved to reduce the call box requirement from 300 feet down to 113. And there was a number of conditions that dealt with drive-through hours. There were some pine trees that were required between them and the residents. Additions of a wood fence that were directly behind the call box itself to kind of project the sound out towards Gratiot. And then a final site plan must be approved by the Planning Commission. So that site plan was approved by the Planning Commission and it met those requirements. Subsequently, as you see, the site plan you see here is the old one because that's what was approved by the Planning Commission. A new user has looked at the site and they have what you see here as their new proposed layout, but they are proposing to move their call box a little bit closer to the residential properties than what was allowed previously. So the departments internally looked at this. Assessing had no assessing requirement objections. Building department noted it didn't create any building code issues. Fire and public works had no issues and no comments. Engineering noted the proposed location of the call box is within the close proximity to the existing homes to the west and north, which could lead to disturbance. The developer has proposed some landscaping in the greenbelt. They would like to see the landscaping in the greenbelt and the call box to minimize the disturbance. The current plan shows detention along the west property lines, north and west property lines. However, with the latest revision of the engineering design and construction standards, there may be alternatives. Therefore, at this time, detention cannot be considered a practical difficulty with respect to the call box location. Melissa did look at this for the planning department and noted that a grant of the variance would allow the property to develop as a normal C2 zoning district. The site is intended to be screened by a 6-foot tall masonry wall. If the zoning board of appeals finds these screening measures acceptable, again, at this point they're not offering any landscaping other than the masonry wall. So that would be something that you guys could consider as a conditions should this be recommended for approval. The 300-foot setback requirement from the north property line appears as though it could be met, but the call box would have to be placed very near the gas canopy. The 300-foot setback from the west property line physically cannot be met. The property is not even wide enough for 300 feet. So in looking at all of this, I think staff is generally of the opinion that the ZBA has already granted a variance here. So you've already acknowledged that a practical difficulty exists based on the size and shape of the property. This request, however, would seek to move the call box closer than it was previously approved. However, the previously approved call box was more of a traditional call box that you might see at most fast food drive-thrus that you go through. But what's being proposed this evening is actually much more non-traditional. It's a touch screen essentially. If you've been into a lot of fast food restaurants now, if you go inside, you order yourself by touching on the screen. This is the same concept. The vast majority of the orders will be simply the user touching the screen. However, they do have a function for help, which has a speaker, which is why we determined that this is a call box, and therefore it would need to meet the ordinance requirements. So, given the nature of this process, staff would support the variance request, as you've already identified that there's a practical difficulty here, but we would defer to you as to what other screening measures might be needed.
All right. Any questions from the board for Mr. Box? Hearing none, is the applicant in the audience? If you are, please feel free to come forward, state your name and address, or both your names and addresses for the record, and give any comments you might have.
Good evening. My name is Derek Reba. Address is 4270 Morris Road. With me, I have Bob Kirk, and mind to share your address, Bob?
19500 Hall Road, Clinton Township. I'm a municipal land use attorney working with this group today.
Thank you.
Yes, to further introduce myself, I'm with Skilk and Gold, Sheets preferred developer for the Michigan area. Thank you guys for being here tonight. Thank you staff for putting together this report. Before we get into the actual variance request, if I could run through this little presentation, tell you guys a little bit about Sheets, and then we can get into the request.
Oh. And if you can just keep the microphone a little closer, I'd appreciate it. Thank you.
So, starting with who Sheets is. Sheets is a family-owned business that was founded in Altoona, Pennsylvania in 1952. Started as a general restaurant and carry-out, has grown today to more than 700 stores, and they're now offering a fuel station. All the stores are still family-owned and operated. Start with the exterior of the building. We have four-sided architecture here at the Sheets buildings. This allows good curb appeal from all sides of the building, not just from the roads. They offer outdoor dining for those who choose to enjoy their meal there on site, and then additionally, high-quality building materials, including brick and stone, all across this building. Once you get on the inside here, you'll find that they have a full made-to-order kitchen. When I say made to order, they have over 1 million different food combinations you can get. You can customize any item however you would want. If you want breakfast at night, you can order breakfast at night, or if you want lunch in the morning, you can order lunch in the morning. In addition to that, they have a coffee bar, full service coffee bar. Anything that you find in your other major coffee joints, you can get here at Sheets. And lastly, the convenience. They have convenience items and some home items that you might need during the off hours when a Target or whoever isn't open to offer those to you. In addition to the outdoor seating, they also have 30 interior seatings for you to enjoy your made-to-order food. As Josh mentioned in his report here, all the ordering is through either an app on your phone or a touchpad menu. There is no face-to-face interaction. It is on a touchpad. It prints out a receipt for you to take to the counter and pay with your convenience items if you choose, and then it sends it back to the kitchen. Kitchen calls your number when your order's ready. That same principle applies here in the drive-thru. You touch a screen to order in the drive-thru. There is no back and forth. There is a button for help if you're having technical difficulties. Generally speaking, though, people who are struggling with a touchscreen are just going to pull forward to the pickup window, and they'll take their order there. So now we can get into the site a little bit. As you all know, this is on Gratiot Avenue. It's approximately 3.15 acres of vacant land today. That's zone C2. So we're here to request a variance to the same section of code, just two different frontages here, one from the north and one from the west, 99.1 feet and 82 feet, respectively. So as I kind of just mentioned, this is a touch screen. You can see those photos there. In the drive-thru, you can order both made-to-order food or convenience items, so things from the coolers, etc., and then you pull up to the window and they hand you your order. In the event that you are having difficulties, there is a help button where you can speak to someone inside and they can give you a little bit direction. As we mentioned, this generally isn't the method of ordering here. So you'll see here we've added significant landscape buffering here along the north and west sides where the residents are today. We've actually doubled the plantings from the previous submittal. There's a 6-foot masonry wall that runs almost the entire length of that property line there, at least to the edge of where those homes end. We've also significantly improved this plan as far as shifting the focus of the business to Gratiot and Hall Road as much as we can. We've reduced parking. We took this plan from 2 buildings down to 1, and we significantly reduced the building footprint here. This building you're looking at is 6,139 square feet. I think the original site plan here included over 15,000 square feet of building. Here on the next couple slides, there'll be some renderings of what we expect this site to look at here when it's all said and done. You can see there on the left side of the screen and on the top of the screen, the masonry wall running that length of the property line, and then you can see those trees there. There is some dry detention on that side as well. You can see kind of the indentation in the land a little bit more visible from this view. That's the conclusion of my presentation. Bob, I don't know if you have any additional supplemental information you want to provide.
Just a couple of items from my end. I sit on your side every other week in the community. What's a call box? Normally you look to the ordinance. You have no definition of call box in the ordinance. I gave you a letter, the Merriam-Webster Dictionary. Call box traditionally was on the side of a road for emergencies, like a direct kind of dial for help. This one there's no call box, it's a touch screen. So we don't think it falls into that category, but we understand Josh's interpretation, so we're asking for the variance, but we'd ask you to consider that it's not a call box. With regard to practical difficulty, it's already been determined by the board, but a little bit of history on this. I've been around this township like 30 years. And when they widened Hall Road, Macomb cut up a lot of odd pieces here where the commercial isn't real deep on Hall Road as compared to the south side, so you have no malls, dealerships. So we're left with parcels like this, and I think this one was bought by MDOT from the original owner because they cut it up so bad. So it is kind of an odd configuration, not too much depth, off of Gratiot. So it is an odd configuration. I think that's what helps determine the practical difficulty. Also, the 300 feet, if you really think about 300 feet, that's a football field. I don't know any communities that would have such a requirement. I know the township's looking at maybe revising that. As Derek said, the plan that you approved the variances for were 2 buildings, 15,000 square feet, no known users. Here we know the users. I sent you, in today's submission, I gave you the breakdown of what we expect through the drive-through. There's 700 stores, and that's a 1-year time period of what they expect, 2-3 cars an hour. So it's not a real intense use. Even reducing the 2 buildings on the prior site, we have 23 less parking spaces. So I think we meet I don't think we have a call box, but I'm not gonna argue about it, just have to make my record, and I think we meet the practical difficulty.
Very good. On that last point, I just want to confirm, you are aware the ZBA does have the capacity to do a definition decision on the ordinance, correct?
Yeah, that's what I'm asking for.
Are you asking for a definition? Because my
you have-
reading of this was that you're asking for a variance, and I'm hearing some definitions. I just want to make sure what you are asking. the
Our
ZBA.
application asks for the variances, but I think the ZBA has the power to make determinations. It could come to you and you say, this is before us, but we don't deem this to be a call
So
box.
I guess what is puzzling me is you're bringing up the definition, but you didn't ask for a definition, so I'm
I don't think you can grant a definition. I think you can determine whether or not it is or it isn't.
correct, but you didn't ask for one. So I just want to make sure the issue of it being a call box or not is not at issue tonight. Is that accurate?
I think you can make that determination. I've been doing this 30 years, but go ahead.
I would ask our legal counsel, can we just go to a definition when there's a variance being requested?
I would say no. The application process has to specify what the actual request is, and then there's notice requirements that go out to the public as to what issue is before the board tonight. And my understanding is, and Josh can correct me if I'm wrong, but the application was strictly for a variance request. The ZBA may have that power if an application was submitted to ask for that, but that issue is not here tonight.
Okay, and did you have any, and again, I'm just making sure I'm understanding what we're looking at tonight. Did you have any feedback or comments on that?
So we never got an official determination. It's a call box. It was part of the review, and so I'm bringing that up, that I don't think it applies. You could, it's your
Okay.
choice. I'm just
All right.
making the record.
Understood, I think, and I'm, just so I'm on the record as well. My understanding is that we are not being asked to rule on the definition of call box. We are strictly looking at the variance request for the distance tonight. So I just want to make sure I'm on the record for that as well. All right, very good. Is there any questions from the board to the petitioner?
I have
Go
a
ahead,
quick
Mr.
question. I know it's a touchpad, but it says it has a help button. It says it's not used very often. Can you give us any numbers, how frequent it happens, percentage-wise or number-wise?
I don't have a percent, but if you do look at that supplemental information that Bob provided, you'll see that the average cars per hour, generally speaking, we is 5.8 or so on a peak hour. I mean, if we assume less than 50%, that would be maybe 2. I don't speculate that many will use that feature.
My concern, because it is so close to residences, and I assume this is still going to be a 24-hour operation like the other ones?
Yes, sir.
So if someone needs help at 1 in the morning and it's loud for a resident that's right on the other side of that wall, that's my concern, is protecting the residents for this.
I don't think they keep numbers, so I can't give you that height or anything.
It's hard for them to provide any statistical data on how often someone needs technical support. I can tell you, generally speaking, the volume of orders is happening inside the store or on the app. It's not happening through the drive-through, which is why we provided you those drive-through counts.
Any other questions? Go ahead,
Mr. Chairman,
Go ahead, Mr.
if I may.
Yeah.
To the petitioner, let me start with Mr. Box. Do you know the decibel level of a generic call box based on our ordinance?
Our ordinance doesn't have a set decibel level for a call box. We do have a noise ordinance that sets decibel levels at the property boundary. They would need some sort of an acoustical study, I think, to tell us how loud this is at the property boundary. I think the previous applicant who was approved of a variance on this location did just that, and largely the ambient noise from the traffic on the surrounding roadways was significantly louder than what the call box was going to be. That being said, that operation was also not 24 hours. It was, I don't recall exactly, but it was limited to certain hours.
Okay. And to the petitioner, do you have any of those studies that you've done in the past? Maybe, I understand not at this location.
We haven't done one specific to this location. We have done one for another location here in Michigan. We have the same conclusion. The general site noise on a sheet site with a drive-through is no louder than the car passing by cars on the road out front.
Okay. Thank you. Mr. Piper took my other question. Thank you, sir.
Just so everyone in the audience also understands, we will have public comment in just a moment, so just be patient. Mr. Coster, go ahead.
My question was similar about the decibels. I didn't see anything in here, any type of study. Additionally, I believe that call box that we approved previously was one of the first ones we had with, I don't know the technology, but it was newer technology, adjusted the decibel lower at certain times to ensure it was lower than the cars running back and forth. I didn't see that in this packet here, but that was my question as well.
Anyone else? I did have a question. So we have approved a variance for this site, and we did determine there was a practical difficulty. I think as Josh had mentioned, I think that's on the record. Typically, when we approve a practical difficulty, we do, and I believe the ordinance specifically has language to this effect, although I don't remember it word for word, that refers to something, I'm going to paraphrase, something in the nature of the minimum required. So we have determined there is a practical difficulty here. However, you are asking in addition to what has been granted. So obviously, we have an example that shows this parcel is developable with the variance granted with a call box, and you are looking to exceed that. Obviously, this is an unusual parcel, as you mentioned. That was part of, I think, our reasoning when we granted it however many years ago. However, I do think this is an ordinance that, like all of our ordinances, we try to maintain, and we try not to give more leeway than is needed to reasonably develop the property. I believe a site plan that shows it usable, to me, seems like it means that it could be reasonably developed with that variance. And so I guess I would ask, what about the parcel do you believe makes it required to have a larger variance than was already granted for a developable use?
It would just be our proposed use in our building. I think the prior plan had 15,000 square feet, more commercial towards the residential. We actually pulled away from the residential besides this call box. I think there was a 8,000 and a 10,000 foot retail building. You don't know what was going to go in there, what was going to abut that residential. So we think we've improved the plan by taking 2/3 of the building away. And we need X amount of space in the front for the gas canopy. So we did the best we could to pull it away, but we think we've improved the site in relation to the residential.
So to make sure I'm understanding, your position is that you're improving the site, it makes it better for the site and for the surrounding, not necessarily that it's not developable as we originally gave the variance for.
No, I'm not sure developable is the test, but this is our layout. Each property is unique, each plan is unique. So we did the best we could to pull it away from that residential.
And I'm just going for my memory of it. Do we, Mr. Box, do we have the variance granting language? I think you might have had it up there. Do we have the practical difficulty stated in there? So it just has the restrictions in there. Okay. And I guess I would also ask that, with regards to this request, we had a couple of pretty specific restrictions on there with time. I just want to verify you guys are looking at this being a 24/7 drive-through. Is that accurate?
That's correct.
Okay. I believe that there was a wood fence there, and again, I was trying to find the video of this meeting, but I don't think we have it up anymore, so I'm going to go by memory and the wording. I believe there was a wood fence that was requested to maintain vegetation around the perimeter of the property, which is different than our standard, but it was an attempt to maintain sight lines. So I noticed that's not on yours.
We actually have a masonry wall.
Correct, and I believe that, and again, the video would not be online, so you would not have the benefit of maybe understanding this detail, but I believe the discussion at the time and the reason the wood fence was requested was to avoid the necessary tear-up of trenching a 48-inch footing and the surrounding vegetation around it, because there's significant vegetation around the perimeter of the property that can aid with the light and sound mitigation, which I believe is why normally we would require a masonry wall. In this case, it was part of the variance. And then additionally, you did have a significant number of landscape plantings, but I believe that our initial granting specifically referred to the height. I believe we mentioned 18 and 20-foot trees. I just wanted to verify that was not something that you guys had put on your drawing.
We had not specified the same plantings. Like I said, they had shown 15 plantings. We have 30 plantings. If you like, I can have Eric Williams, the civil engineer, speak to the specifics of those plantings and what we intend to put in at the time of planting.
Okay. All right. Very good. Go ahead, Mr. DeCoster.
When it comes to an online order, if someone's ordering on their phone, can they go through the drive-through?
Yes, but they bypass this order station and go straight to the pickup window.
That's what my question is going to be. We talked a little bit about definitions, and I don't want to go in back and forth on that. Has Sheetz ever done a touchscreen box without the help feature?
They have not, to my knowledge. This is a help feature in case there is technical difficulties at the screen. That's the only intent, is so that whoever is there can say, hey, this isn't working. And as I mentioned before, generally they're going to say, please pull ahead to the window and we'll help you.
And that's my next question was going to be, and I don't know if you can answer this, this may be a programming thing. If you push a help button and the screen says, please pull around to the window, so there would be no verbal back and forth. Again, I don't know about the definition with the terminology of a call box, but if we're reducing the amount of verbal back and forth, does that help this situation?
Yeah, I don't know if Sheetz has the capability to remove the call box. I think this is a standard item. It is a standard item installed at all their locations with drive-throughs. I don't know that they've changed their prototype at all in any other instance.
And then one more question maybe for Josh. When it comes to call boxes, and if the applicant was to meet the 300-foot setback from residential, is there a time constraint, or is that just something we put because we allowed the variance?
It's something you put.
Okay. That's all I have for now.
Any other comments, questions? All right, hearing none, without objection, I'm going to open it up to the public. If you have comments tonight, please feel free to come forward to the podium. State your name and address for the record. You have up to, I might get this crossed up with the Planning Commission, but you have 4 minutes to give any comments you might have.
Good evening, Mr. Chair and members of the board. My name is John Parkinson, 24261 Darwin Street. I am the colonial, the only colonial that backs up to that property. If it please, can I approach you guys with some pictures from my bedroom and my master bath, or my master.
Certainly,
As long
again,
as they
as,
point outside.
What's that?
As long as they point outside and not inside.
Yeah.
Watch the step.
and mind the step, yes. Thanks, sir.
So I took those today. One of those is going to be for my master bedroom. That overlooks the majority of the property. The other one is my bathroom that overlooks the rest of that property. You guys answered a lot of the questions I had. I was going to ask you where the variance would set the call box, and I'm going to call it a call box, and what changed from the previous plans. Why aren't they building what they proposed? We were all set for that. We know that this is a 24/7 drive-through. Previous plan did have restrictions, and we were set with that. We were understood that that was going to be what was going to be put there, and you guys are aware. They've acknowledged it. So has Sheets ever not had a call box or not had a drive-through? Can they go in and order just only? That was a question I had. But I would like to play this video real quick. I know it's going to take up some of my time, but I got a lot to say. So I just want you to hear this. Because I after I found out what this project was, I actually looked into it, and I'm like, well, okay, let's find out. So.
I've never seen before, a Sheets drive-through.
Hi, welcome to Sheets. My name is Lauren. Let me know if you have any questions with the touchscreen.
Okay. With that said, Lauren asks, let me know if you have any questions with the touchscreen. That was her introduction. Okay? Allowing this would not only add additional noise pollution to our backyards, it would reduce the quality of life for our family. It would also put cars with noisy radios and mufflers closer to our property line. Our property is a two-story home with a master bedroom and bathroom overlooking the greater majority of the proposed project, and it would be greatly affected. I was going to ask, did anybody do a decibel study where they proposed a setback? That's been addressed. Did you use a loud muffler or loud boombox with enormous bass? Because that's what we're going to hear. If we can hear the speaker across from Gratiot at Russ Milne when they call the sales guys, how much more are we going to hear from a closer speaker at all hours of the night? According to the newly revised and adopted noise ordinance, approving this could, and I'll say could, be a violation in itself. If Sheets would like to buy some of the properties that's going to affect this project, we're open to discussion, okay? Additionally, there's a group home right next to us. They're not here because it's a group home. This would affect them as well because they share the rest of that back area. So, and how tall the trees are they going to propose? We talked about this before. You know, I've got a colonial. It covers the back side, almost the whole back side of that. Can you pull up a picture? I can show you where my, pull up the picture with our property if you wouldn't mind. And I would like to show you where we sit so you guys can understand why I
Mr.
think.
Parkinson, I'm going to have Josh pull it up, but just so you know, you only have about 20 seconds left.
Yeah, it's fine.
What
go ahead,
picture
Josh.
would you
I'm just
like?
going to say for these reasons, we are respectfully asking you to not grant or approve this variance for this project at this time. Okay, that big property right up there, can you, yeah, right there, that's me. Actually, go up further. I believe that's me right there. Okay, so my property line goes up almost all the way to that corner. Go to the right there, up there a little bit to the corner, right there, and it goes all the way back to about right there. There's a telephone pole there. Okay, that's my property line. So I appreciate you guys if you guys would consider voting no on this. Thank you.
Anyone else?
My name is Philip Zioli. I live at 24204 Darwin. I've been sitting in the back row. The first person that was up here you people discussed his issue for 35 minutes, and that was over a patio that was 2 feet too close to a fence. And now you're telling me you're going to allow them to put a call box closer to us? Why? is this call box going to be accessible from a car? You pull up your car and reach out and do the call box? What happens with the diesel pickup truck comes in there and he's 3 feet above the call box? Has he got to get out and let his car idle and we've got to listen to that for his order? Somebody want to answer these questions? Am I going to have to listen to diesel trucks pull up to a call box? I have trouble with them when I'm standing in front of them at a McDonald's. You're going to do it from a car. Good luck.
Hi, Carol Sutherland, 45333 Abington Circle. I have a suggestion and maybe a question. Have you guys ever come to our subdivision? Have you ever come to the site? These are our homes. Have you been there? Did you come in our backyards? Did you see? I mean, if this call box is closer, aren't the cars going to be closer? I mean, she's just not this mom and pop store that they're making you seem. There's how many offers or proposals in Macomb County now? 2, maybe 3 in Macomb Township themselves. How many gas stations do we need? They go to these municipalities and they're turned down and then they come right back. What's going on? I mean, we are residents too. This subdivision was here long before they made Hall Road. We deserve some respect, and I hope you vote no.
Anyone else?
I'm Walt Sutherland, 45333 Abington Circle, the very northwest corner of that drawing you have there. That would be my house. It's a little taller, not as tall as John's, but it's set up higher. I can see through most of the trees there. Some of the questions that I did have for them is what I heard was this is still a call box. You push for help. Well, who isn't going to use that? If you're at my age at 77, chances are 98% of us are going to push that call back. Another thing they were telling me just recently here was that it's like 2 or 3 cars go through there. Now, does this warrant 24-hour service? Now we got some drunk pulling in at 3 in the morning, just coming from the saloon, and not figuring out how to work the callbacks. First thing he does, push help. Now we're listening to him for maybe 30 minutes. Did you want that? No, I wanted something else. And then they go over and through it with the help. The trees along that that they showed in their drawing there, they're barely 6 feet tall. They're almost as tall as what they showed that the brick wall that they had imagined. From what we understood the last time, they were going to be around 20 feet tall and a lot closer together, which would have made a lot of difference on knocking down the noise. That's about it for me. Thank you.
Just so you know, I think that timer was from the last person. You had another minute or so if you wanted it.
No, that's good.
Very good. Thank you. Anyone else?
Good evening. My name's David Harms. I live at 24240 Darwin. My driveway is right next to the group home there. And if you let this go through with all the lighting and the noise, it's definitely going to change the quality of our life. I mean, we're going to have people sitting in my backyard eating out now. Where are they going to pull a tanker in there? I mean, it's like trying to put a whale in a minnow bucket. It's not made for that, especially a 24-hour gas station. I mean, we have a life too, and we need to keep it. You know, we've been there for almost 25, 30 years, and this is kind of gut punching. So I hope that you don't approve it. Thank you.
Anyone else? Hearing none, without objection, I will bring it back to the board for any comments or questions.
I have one, Mr. Chair.
Go ahead, Mr.
Back to the petitioner. Josh, can you go to the site plan? Thank you. Have you tried, what's the issue with other configurations? Like if that call box, let's call it what it is facing Hall Road. Is that feasible? I mean, like, just,
If you go to the renderings, you can see how the pickup windows are oriented. I don't know if you can pull those up, Josh. So the queuing for the drive-through there is along what is now the north side of this building. And if you go to the next, is that me? You can see there the drive-through queue lane then travels along the backside of the building, and there's your pickup window. If we were to rotate this so that the call box were facing Hall Road, the back of the building then would be facing Gratiot, and all of the business entrances would be facing the residences. This orientation puts majority of this business's traffic, i.e. the fuel canopy and the main entrances of the building, both towards Gratiot and Hall Road. And then it puts the drive-through, what is really an amenity, to the rear. So our heavy traffic is pushed away from the residences as much as we can.
okay, thank you.
Just to clarify too,
Go ahead, Mr. DeCoster.
this is zone C2. So
That's correct.
a 24-hour gas station is allowed without any variances.
Correct.
We're here tonight about the call box only.
That's correct.
I understand, we talked a lot about call box before, our ordinances for how many vehicles need to queue, so I understand your proposed layout. Again, I don't think we have a previous variance that we've approved. Personally, some of the stuff in your variance request doesn't meet the intent of what we approved previously with regards to the trees, the heights of the trees. Again, I'd go back to, I don't know if it's something that Sheets can do. If you push a help button, the screen says, please pull around, and you lose that verbal back and forth. Again, is it called a callbacks at that point? I don't know if that, we could have discussions on that, but I know you've taken drive-throughs out of other locations here in Michigan. I'm not saying that that needs to be done here, but is there anything else you can do to remove that verbal communication? Because a 24-hour operation does not meet the previous variance request. It sounds like we don't have a design on the trees yet. It sounds like we don't have a decibel level in the decibel study that we had in the previous one. So at this point, I'm not quite convinced yet where we're at.
Josh, can you clarify the variance that was previously approved? I believe it was for 113 feet, where we're requesting 99 now. Was that 113 from both?
113 was the shorter distance, so that's all they really asked for, because the further distance, so it would be the same as you guys asking just for 82 feet, rather than the 99.
Okay. Yeah, so I guess the point I was calling out is we're really asking for a 30-foot difference there to the west side. It's not a major change. To your point, I don't know that we can reorient the building. We could look at shifting the call box potentially, but then that creates some queuing issues that I don't know that the staff or.
Yeah, I don't necessarily disagree about the 30 feet.
Yeah.
Again, but with the tree height, the hours,
Happy to put in taller trees. We just, we kind of went with what would typically be given to residents in this area. If they would like to see some taller trees, we can discuss that. That's not off the table. I think just the main thing is the call box moving isn't feasible from a layout perspective. Happy to provide additional buffer in any other way that you guys find necessary.
So I would just make one comment. I think this would go back to my comment earlier, and this is kind of where I'm thinking with this, so that you know. You said that it's not feasible with the layout. Well, we know it's feasible. We had a layout. We approved a layout. Now, granted, may not be feasible with the layout that you would prefer, but I believe that our job here is to find what would match the ordinance and impact the least. Last time we were here, we did look at it. We said there is a necessity here. It's an unusual lot size. It's a small parcel, it's in C2, it's at the corner of Hall and Gratiot. These were clearly elements, I think, that we looked at. But I think incumbent on that is also to affect the parcel as much as possible. And for myself, outside of the other restrictions and requirements, we want to affect the neighbors the least possible. I mean, last time there was somebody here, we told the neighbors, hey, they have the right to build something here, and we believe the property authorized it, but we also told them, we feel you need to do the minimum necessary to be able to allow it on there. And so to me, just structurally, this increases that, and we know that the parcel can support a call box to a lesser degree. So
if we committed to a nonverbal help button, is it still considered a call box? Do we still need this variance?
I think that would be a different request, that I don't think we're prepared to answer that tonight.
If we do consider it a call box, could we approve this variance, noting it a call box, with the condition that there's no verbal communication with it? Would that satisfy this variance request?
I mean, that's a condition that you can put on it. If you call this a call box and you prohibit a speaker, I suppose that's a condition you could put on it.
It would be a way to continue, and I'm not saying get it approved, but it would be a way to continue with this motion tonight, or this item tonight, is if the condition was to include no speaker in the call box. If you call it a call box.
Yeah, I mean, to be clear, I understand their point that it's a help button, it's used on rare occasion. Our staff's perspective was the fact that there's a speaker there means it's a call box. If the speaker went away, I think staff's perspective is it's no longer a call box. Ultimately, you guys can determine that if that is accurate. If they want to make if you want to make a determination on that, that can be requested. But that's how we're going to interpret it until you tell us otherwise.
I think that was what I was saying, is if we still consider it a call box, but put the condition of no speaker, I think it meets both. I mean, I guess you can call it what you want. If there's no speaker, there's no speaker. But I'll let us discuss that.
I have one more.
Go ahead, Mr. Gamicchio.
Josh or the petitioner, has this gone before site plan or approval for the planning commission?
No. We still need to do that.
Okay.
This is the first step in this overall process.
Thank you.
Mr. Chairman, I'm going back to 2021. That, to me, that 300-foot ordinance is in place for a reason, and I was against granting the variance last time. The board didn't agree with me, but this is even more so. Even one person talking at 1 in the morning to me is not conducive. The ordinance is there for the protection of residents so they can enjoy their property as well. This would be, no, please, no. I still feel the same. I haven't been convinced otherwise that this is a good thing to do. I felt at the time the practical difficulty of the property, because it was not 300 feet wide, was a practical difficulty, but I felt the owner of the property was a self-imposed practical difficulty because he bought it knowing it wasn't 300 feet wide. So he knew in advance that he couldn't put a call box there. And I haven't been convinced any differently. So I would make a motion to deny this variance. Actually, I guess there's 2 variances. Do I need to make a separate motion?
I think we would need to do a seperate motion if you're going to make a motion.
So I will make a motion to deny the variance, section 10.1603B33A for a 99.1 foot setback when 300 is allowed. Because I don't agree that it meets the spirit of the ordinance, and to me, the practical difficulty is self-imposed.
All right. Motion by Mr. Piper. Is there support?
I support that.
Supported by Mr. DeBruin. Discussion on the motion to our legal counsel. This is the same section. There's 2 different distances. Should we make this 2 different motions? I think there might have been 2 different applications or 2 different items. How would we best approach this?
I don't know if there were 2 different applications, but 2 different motions is appropriate.
Yeah, it was 1 application, but they asked for 2 separate variance requests. So I think it should be 2 motions.
Okay, very good. And just to
So my
clarify,
motion
that
then was for the first one, the 99.1.
okay, and that was motion by Mr. Piper, support by Mr. DeBruin. Is there any other discussion on the motion?
I do have just a discussion point. Again, going back to my comment, I understand your position with a verbal call box. If we deny this variance request without the condition of the no speaker, we're denying the variance request. Would you be open to a motion to approve it with the condition of no speaker? It would still be, I think, for the spirit of what we're talking about here today, it's still a call box, but we don't have the speaker element.
I will amend the motion to say if it's a call box that has a speaker in there, so.
I actually supported based on the fact that if it didn't have a speaker, they wouldn't even be before us. They would just be putting a screen in and they wouldn't have to come back. That was my assumption.
Just for the discussion's sake, my opinion, for whatever it's worth, is that a variance wouldn't be required at that, potentially would not be required at that point, and so it would be redundant. But it would be up to you how you want to state your motion, and up to Mr. DeBruin if he wants to second it.
I will restate my motion to say that, that I'm denying the motion for a call box with a speaker at 99.1 feet away when our ordinance calls for 300 feet.
Okay? Mr. DeBruin?
I once again support that.
Okay, and just checking, are you okay with that the wording of the motion is clear?
Yes.
Okay.
Well, I'm sorry, the reason for, please state the reason for the motion too, in there, right?
Yeah, my reason was that it doesn't meet the intent of the ordinance to protect the surrounding residents. That's the reason we have a 300-foot ordinance.
The issue being of a practical difficulty.
I
You
don't-
mentioned that in your first motion, but not your second motion.
Right. So, well, yes, I don't think it meets the practical difficulty because of the fact that it doesn't meet the spirit of the ordinance.
Can I ask a couple more questions?
I believe on the discussion of the motion, you can regarding the motion, but not generally.
Okay.
I believe would be how it would go.
Then stop me if I'm out of line here.
Okay.
If we deny this, we can't bring it back. It's done.
So they're asking for variances for specific dimensions. So the first one, the motion was made for 99.1 feet. If they came back and asked for 99.2 feet, that's a different request.
Can we make a motion to table?
They make the motion.
We do have
Can you?
We do have a motion on the floor. Mr. Piper could suspend his motion if he wishes, but he is not required to. I believe. I should verify.
That's correct.
Mr. Piper, it would be up to you if you wanted to table or not.
I will allow it to suspend if they want it.
And Mr. DeBruin, would you support?
100%.
All right. Do I have to call roll when a motion is suspended or a motion is withdrawn?
I think someone needs to make the motion to table.
Correct, but with regards to Mr. Piper's motion, he withdrew it. Mr. DeBruin withdrew his support. The motion is now gone.
Yeah, it was his
Okay.
motion. He can
Very
withdraw
good.
his own motion.
All right, the motion is removed.
Mr. Chairman,
Mr. Gamicha, go
I
ahead.
would move to table item 8A, B,
8B?
8A and B.
No.
I believe it would just be 8B. And if you could, just to
8B.
clarify, you're requesting to table both of the requests.
Yes, sir.
All right, go ahead, Mr. Gamicha.
Do I need to specify a date?
Yes, we should specify a date. Are you requesting a specific time? Our typical
once a month.
Our typical ZBA meetings are the first Thursday of every month. Do we have one in December, Josh?
We will.
We
Yes.
do have one in December. Obviously, we don't know about January
I
yet.
think 1 month will be sufficient as we sort through this.
I would motion to table until the December ZBA meeting.
Okay, motion by Mr. Gamicha. Is there support?
I'll support that.
Supported by Mr. Piper. Mr. DeBruin, please call the roll.
Mr. Gamikia.
Yes.
Mr. Piper.
Yes.
Mr. DeBruin is a yes. Mr. DeCoster.
Yes.
And Mr. Tuckfield.
Yes.
Motion passes.
Thank you.
Thank you all
Thank
for
you,
your
gentlemen.
time.
All right. That takes us on to, let's roll all the way back up to my agenda here. Takes us on to public comments. This is item 9. If there's any member of the public who would like to speak on this request, you may do so for up to 4 minutes. Please state your name and address for the record. Thank you.
Hello, board. John Parkinson, once again, 24261 Darwood Street. Just want to thank you guys all for your consideration, especially the gentleman on the end there. Knowing that the 300 setback is not within their variance request was not within the spirit of the township setback. you know, obviously, I had to take a very important night off. I'm part of Trail Life USA. I guess I'll have to do it again in December because we'll be back here. I'm not sure why they wanted to table it. Maybe they're going to take the call box out, the speaker out. That's fine. But when they do come back, we'd like to hopefully have them have a better plan for you. It seemed like they weren't well prepared and didn't know what they were doing. And I understand this gentleman here pushed for this thing to get done tonight, and appreciate that. But you know, as residents, and we've been there. I've been there for 15 years. I've been in the township for over 20. And I would like to see some peace and tranquility. You're going to put this, and I know I probably have to deal with this with planning as well, because regardless of the box, there's still going to be cars in that drive-through that are going to be closer to my property line. So when that does come around the planning, are we going to get notice for that? Or is it just going to be a planning commission meeting where you have to watch out for?
I believe there would be notice within 300 feet, Mr. Box. Yes.
Okay, yeah,
For the site plan review, if it would come to that.
Yeah, because that's very important to us. You know, the vehicles behind my house at all hours of the night. You know, again, I'm the Colonial. My master bedroom was there. I mean, yeah, we could close our curtains. We typically don't, but we could close our curtains and it could dark out whatever the light. But it's not gonna reduce the noise. So there's still going to be noise from the vehicles, noise from the dump truck. We don't know what time they're going to pick up the garbage. The garbage is closer to the property line. There's a lot of factors in this plan that they're proposing, and I'd like you guys to do your due diligence, and I know you will. I know you work very well, Mr. Tuckfield, Mr. Chair, and I appreciate your guys' due diligence when you look into this for us, because you know, the residents, we've been here long enough, and you know, Sheetz is just, you know, it's now not a mom and pop, like someone said earlier. It's not a mom and pop shop anymore. They're expanding everywhere, and you know, the hardship is it's a property that's not really conducive for that type of project. I mean, let's restrict it a little bit more, and you know, give us something else. You know, hours of operation, 24/7. My life. If this project gets approved, that drive-through gets approved, my sleep patterns are going to be crazy. I'm going to have to call the Macomb County Sheriff all the time because of this noise ordinance that this township approved, and it's going to violate every bit of that. I'm sure of it. I want you guys to keep that in mind when you guys are approving this stuff. Thank you.
Thank you. Anyone else?
Andy Siddle, 44975 North Gratiot Avenue, Clinton Township. We are across the street from that BP gas station. We own that gas station, actually. Just want to get you guys an idea that this property is developable without the drive-through. The C2 allows it without that drive-through. Last time you guys approved it and had no problem because there was a lot of restriction towards it. But this property is allowed and could be developable with no drive-through. Thank you.
Anyone else?
Carol Sutherland. I just wanted to invite you all to come to our neighborhood, and we'll be glad to take you on a tour so you can see exactly how this stuff will affect our homes and our lives. And there's a place to park. You can park anywhere on the street. You can park in our cul-de-sac. So if you're open for it, come on down.
I appreciate it. Anyone else?
Okay.
Seeing none and without objection, I'm going to close the public comment portion and bring it to the ZBA member comments. Any comments this evening?
I do have a comment. I will say that I am very familiar with the neighborhood. I have walked it many times. I've been a resident for over 40 years, and I remember that parcel real well. That actually used to be the bypass lane that would get you onto Hall Road. So, and that's why it's such a funny shaped property, because of that. The road commission kind of did that when they expanded M59. So, but yes, I'm very familiar with the neighborhood. When my car is in for service at the dealership across the street, I walk through there just to kill time. I know the area real well. Yeah.
Mr. Chairperson, I have some comments as well.
Go ahead, Mr. DeCoster.
I think one of the comments was that I was trying to pass it tonight. That was not necessarily the case. I was willing, from what I heard in front of me, I was willing to pass it without the speaker. I thought that was a solution. The applicant tabled it, which I was fine with. My only other concern would be maybe for the planning department, in your discussions with them to bring it back to the meeting, if we could get further information on the height of the trees, some of the conditions we talked about the last time. I thought that was a good compromise the last time we passed it, with regards to the technology and the decibel levels. And then maybe a little bit more information again. Again, I don't think it's up to us to remove the drive-through, but if we remove the speaker, does it still qualify as a call box? If it doesn't, this may not, maybe this doesn't even come back before us, I don't know. But a little more definition on that.
So if I could, for our legal counsel, it seems like that's a pretty separate issue that I don't really want to get us intertwined with unless the applicant specifically asks for it. It seems to me pretty clear cut. Obviously, it does seem to be a little bit intertwined, but I think we should be careful not to mix in a request that hasn't been made.
I guess I'm not saying from the applicant, I'm maybe saying from the planning perspective, in your opinion, does a box without a speaker, is that a?
So, yeah, that's exactly why they were here this evening. I understand that it's mostly touchscreen. Had it been 100% touchscreen with no speaker whatsoever, I would not, as staff, would not have considered that a call box.
Okay. That's what I was looking for, thank you.
But ultimately, the interpretation of the ordinance is your purview.
Understood.
So if requested, even though I say I wouldn't interpret that as a call box, you guys have the ability to interpret otherwise and say, yes, that is a call box. Or you could agree and say it's not, that's your purview.
And that's because it's in front of us now. If this plan, if this
Well,
site plan
if it
came-
were requested
Yeah.
to be a determination.
Okay.
All right.
turn?
Go ahead, Mr. Bruin.
I just want to say I'm continued to be impressed by the staff here in the building department, the way they present things, and I want to thank you for all of that. Also, to this young man who has sat through an entire ZBA meeting, I don't know how you have the patience. I would have gone crazy as a kid, but this is interesting stuff when you get older for some strange reason. And then to the residents mostly, obviously, we are residents as well, but development in this township is paramount to maintaining a tax base and everything else. So it's very difficult sometimes to weigh the needs of a neighborhood, particularly when it abuts such a major area. But our interest is in making sure everything is fair, and it's sometimes it's difficult, but we want to be clinical up here and just do them as they're supposed to be done. And sometimes that requires upsetting some people. So I want to thank everybody for coming and sharing your opinion, because it does help. When no one's here, we have nothing to go on. So, but development is important in the township. I know the building department is acutely aware of that. Thank you.
Thank you, Mr. Bruin.
Can I add one more thing?
Go ahead,
And
Mr.
then-
Piper.
This is what I planned on saying earlier for comments, is I want to congratulate you on your recent engagement.
Thank you, Mr.
Sorry to hear that.
When's the funeral? Careful, Dave.
I know.
She's in the
I
audience.
hope my wife's
listening.
not watching.
All right, Mr. Michi, anything for
I
this
just
evening?
wanted to thank everybody for coming out, and happy Thanksgiving and Merry Christmas. I don't know when I'll be back, so.
Well, we're glad to
Happy
have you.
Valentine's Day. I could keep going.
All right, the only other comment I have, and I think that might have left, is that I would just echo Mr. Piper's comments, and that is that I don't walk properties generally, because there's property rights, and I can't just go on property, but I do walk the public areas often. I think seeing physically is important. Satellite images only give you so much, so.
I wasn't on the property, I was just walking the
And
streets.
I know, but just mentioning it, it's an important thing. Land is important, people's properties are important, and I don't think you can properly appreciate it from a picture. So, the other thing I wanted to mention was thank Mr. Badamo for coming out. He also sat through the meeting tonight. I appreciate it. We requested him, and it's a long night to sit through for the first item, so we appreciate you being here. So, all right, with that, takes us on planning director comments. Mr. Box, anything from you this evening?
Well, we've already mentioned this, but there will be a ZBA meeting in December. I believe there's 2 and now 3 items for that agenda. And I will also say that I will not be here that evening. That will be most likely Melissa here in my absence, so I may not see some of you until after the new year. So happy Thanksgiving, happy holidays. I don't see you first.
very good. Mr. Van Tifflin, anything from you this evening?
I have nothing.
All right, appreciate it. Also appreciate you being here this evening. I don't think you ended up having to say anything, but we appreciate you being here. All right, attorney comments. Jeff, you have anything for us?
No further comments. Thank you very much.
All right, thank you. All right, with that, I would entertain a motion for adjournment.
I will make that motion, Mr. Chairman.
Motion by Mr. Piper, is there support? Support. Support by Mr. Bruin. All those in favor, please signify by saying aye.
Aye.
Aye. All those opposed signify by saying nay. At 8:30 PM, we stand adjourned.
I missed the call from you.